does a non-lawyer who assists a property owner in a short sale transaction engage in the unlicensed practice of law?
I've actually got to ask the audience. I usually get a little bit more involved with the audience, but how many of you out there, and I'm going to read the question back to you, but have at least heard or have thought or have had like butterflies in their stomach about this particular issue, which I'm going to read again. Does a non-lawyer who assists a property owner in a short sale transaction engage in the unlicensed practice of law? Have any of you kind of questioned or thought or like felt like a little uncomfortable with some of your dealings and involvement on a short sale? Is there any hands out there at all? So about 5 or 6 people are putting their hands up. The issues that are out there and the short sale process and the banks, I mean, just to let you know right now, the forum and the way that it's designed is for you, the realtors. The Equator system, which is set up by Bank of America, Chase, Wells Fargo, all of these lending institutions have designed this for realtors to put in their information, to submit the contracts, to collect the 5 pieces of information which you need to collect from all your homeowners, which includes this 2-year tax returns, 2 bank statements, 2 pay stubs, the hardship letter, and their balance sheet explaining what their income and expenses are for the month. Those pieces, as long as you are basically collecting information and passing it on to the lender and taking the information from the lender and passing it back to the homeowner, as long as all you're doing is transferring information, you're safe. The issues that are out there right now is the realtors that are out there writing hardship letters for these homeowners, negotiating the mortgage terms and what the terms are going to be for the homeowners, getting involved in regards to the 1099s and what's going to happen at the end of the year. When you start basically contracting, which we've never done until the last few years because we're now in a short sale market, but when you're starting to contract and negotiate, which is the attorney's duty and what the attorneys are trained to do, you're now treading in unauthorized practice of law territory. And just so you understand the concerns with that, if you're actually in violations for unauthorized practice of law, the penalty, just to let you know, is 5 years imprisonment, $5,000 fine. So it's great. So be very cautious with treading with giving tax advice, giving legal advice, and basically trying to negotiate terms for this individual. If the short sale process isn't going according to the way the homeowner wants it, hire an attorney. If it's not going the way the homeowner wants it, have the attorney just get involved in the last hour, of the step and have them review the short sale approval letter so that he can put a stamp of approval on it, so that you're off. I know a lot of brokerages are also designed where they're building it all in-house and they're having non-licenses doing all the negotiation and the handling of the short sale process, which will only, time will tell what's ultimately going to happen with these entities. But what's happening right now are these short sales that we've done in the last few years have closed, but the banks this year are coming back and saying there's a deficiency we're pursuing against the homeowner. But my realtor told me that they're not going after me and to just sign here so I can make my commissions and that it's done. Have the attorney read that short sale approval letter at the end. Let that attorney write an opinion letter to that homeowner to say your realtor did an excellent job and that the short sale is now done. Let them pay that $250 to $500 for an hour or two of attorney time and be done with it. Put that seal on that work and have that homeowner pay for it. The other issues also are it's affecting also the brokers' E&O insurances as well for the brokers that are out there when the realtors are slipping into these pitfalls. I kind of want to put your thinking caps on as these issues are actually before the Florida bar now. It's not decided yet, but there are cases out there, for example, the state of Florida versus Sperry, and a few other cases where these issues are happening, realtors are being sued, brokers are being involved in these tug-of-wars pretty much with what's happened in the past, and yet we still have at least another couple of years of way more short sales than what we've done in the past. So I just want to make sure that you do get on track. The importance of the attorneys is more important than ever. I can tell you a few years ago, there were very few attorneys that specialize in this area of practice, whereas right now, there's attorneys in every city throughout all of South Florida that are there to help you out. And just make sure that you get your practice and your brokers involved, with that right title company and that right, attorney as well, that's suited best for your practice. It's our duty to basically go out there and educate the community and let them know that we're here to help. And there are alternatives and there are solutions to you. And you've got your attorneys here to help. You've got your title companies, as your partner. And you've got your duty as well to list these properties and help them accomplish a sale rather than foreclosure. The one other thing I want to add in regards to alternatives and where Scott fits in, who also does bankruptcies, I actually recently had a client that after we've represented them for a couple of years, went to another law firm, and she just came back to me this week saying one of my properties ended up in foreclosure. So now we're re-looking at all of her closing documents and trying to find out, who are the individuals that are liable under this promissory note and mortgage. And we've actually seriously got to consider now the possibilities of filing for bankruptcy. Even though the banks aren't going after her yet, the banks have up to 5 years under the statute of limitations to pursue that deficiency against them, which is over $200,000 of liability. So even though the husband's working and the wife's retired at home, they have serious issues to still consider about between now and the next 5 years. And before the banks actually pursue them, we're taking the proactive measure and basically plugging them into a bankruptcy attorney such as Scott that can hopefully help them deal with these outstanding potential legal liabilities that they still have before them, even though they're, the foreclosure process is already passed for them.